Well, thank you very much for coming today. I know what a hardship it is for all of us. Given the playoff game today. So let's, Mike, you have about 5 minutes for the talk. And no. Well, we thought about it, but we don't have broadcast ability. We'll just have to make do. So thank you so much for coming out. As last week, I'm the chairman of the Geology Department, Marcus Bursick, and welcome to the Marcellus Shale Lecture Series. Never realized that was a tongue twister. I'd really like to thank Special Events and Center for the Arts again for all their help with putting this lecture series on. And just so that you're not listening to me too much, let me just cut to the format again. If you didn't register, please do so. It helps us so that we can send out emails if the venue needs to change and things like that, such as it did this week. So far, all the other lectures will be back in 250 Baird where we started. But in case some of the lectures draw more, a larger crowd, we might need to change the venue. So it is really helpful to us for y'all to register. So if you didn't, please do so, either back in the back or on the web. And if you did register already on the web, it's nice to sign in, and we can just know who's coming and what the interest level is in these talks. So we'll go to the talk in a second here. The speaker today is Michael Joy, who helped me organize the lecture series. He's currently a lawyer with Biltikoff and Joy. And no, I guess that's called a partner, isn't it? I'm still a lawyer. Still a lawyer, okay, apparently, all right. But a partner with Biltikoff and Joy. He got both his PhD and his JD from University at Buffalo, so he's, and his bachelor's. Did you get a master's? Probably, yeah. So he's definitely a UB kind of guy. So it's really a pleasure to have him speaking today. His talk is about property rights and political issues related to Marcellus Shale and gas drilling. As before, we'll have a brief timeout after the talk, about 2 minutes or so for people to stretch and for people to leave who need to go watch the game or whatever. And then we'll start on the question period. And as before, we'll let the students ask questions first. Low student population tonight. They had more sense than us, I guess. Then we'll go to general questions, and then we'll go on for 45 minutes like we did last time if there's that many questions. And we'll have a little bit of a refreshments as you leave the door. If you go out my left door, your right door, we listen to you, just like McDonald's and other vendors, and we have some donut holes this time to go along with the refreshments. So have a little sugar jolt before you go, and maybe chat with your neighbor if you want to, and things like that, or other people who are here, and then you're there. So thank you again for coming. It's time to turn off your cell phones, and let's listen to Dr. Michael Joy. Michael.
Thank you, Marcus. That's probably one of the strangest lead-ins I think I've ever had. Lest anybody be concerned that I'm an oil and gas industry lawyer and I come very well scripted for this, I'll tell you that is absolutely not true. Technology has failed me. My cloud computing system is apparently not working, and I have no PowerPoint for you this evening. This behind me is a talk that I gave about 2 years ago in Albany. Frankly, I don't remember what organization it was. I've done about 150 of these lectures in the last 2 years, all in, well, I shouldn't say directly or indirectly related to Governor Patterson's mandate to the Department of Environmental Conservation to do a generic environmental impact statement following some revisions to the Oil, Gas, and Solution Mining Law in 2008. By way of a little additional background from what Marcus gave you, I'm both a lawyer and a geologist, and I work in both professions pretty actively. So I'm unapologetic about the fact that I drill natural gas wells and help other people drill natural gas wells. And until about 2 years ago, that was okay. I could actually go to a cocktail party and tell someone I worked in the petroleum industry and didn't get run out of the room, which now, incidentally, I will. I now tell people that I'm a lawyer. Imagine that. That was actually pretty funny, and I didn't intend it as a joke. That's really where we've gotten to. And frankly, I really don't understand. As I said, I've done about 150 of these lectures over the last 2 years, and this is coming down to being one of the last that I'm going to do. Because frankly, I don't find anything funny about this topic anymore. I really don't find much enjoyable about it anymore. We have gotten to a point in looking at energy policy in this country that it's almost indescribable to me. I'm going to talk about law, property rights, compulsory integration, those very essential legal paradigms that we have that people in New York have and enjoy as it relates to their mineral estate. As a country, we're about on the border of just throwing all that out. We really don't seem to care anymore about property rights. And you can see it by reading the papers almost daily. In fact, this week, for example, some of you may have followed the congressional hearings if you get that strange channel about 800 on your box now that actually shows congressional hearings on a live running basis. They had the EPA in this week testifying on hydraulic fracturing. Now, from the testimony this week, what you get is the EPA regulates it, that the EPA has the ability to issue permits related to injection, and the EPA is looking for more oversight. That's in the last 3 days. If you would have asked me that question on Friday, EPA has never regulated hydrofracking. There is no permit that you can get from the EPA. And according to publications that the EPA has done over the last, say decade or so, the EPA has no interest in regulating hydraulic fracturing because it's not the injection of waste into the subsurface. So some new law must have come out in the last week, right? Everybody saw that? No? You're right. There is no new law. This is just a policy shift at the federal level. Why? I don't know. And I say that honestly, I really don't know. When a client asks me today, what do I need to do to drill a well in New York? I tell them nothing. You can't. That's pretty easy. You can't frack it, don't drill it. Well, what if I want to do it in Pennsylvania? Okay, now I can give you a pretty good lay of the land until yesterday. Now I really don't know. We're looking at a $1 trillion industry. Provides primary heating source for 51% of the population, provides about 23% of our energy. This is domestic natural gas production. And right now, I'm not sure I know the answer about how to go so far as to get a permit. Ladies and gentlemen, this is a problem. For those of you who were here last week, you saw Dr. Torrey Smith talking, our state geologist talking. And at the very end of his talk, there were a couple of very interesting slides. They were basically talking points. One of them talked about the number of people who heat their homes with natural gas. Another one talked about how much energy is produced from natural gas. Another one talked about how many wells are hydrofrac'd. As a percentage, it was about 90%. These are just talking points. I want to take it to the next level and sort of reverse the normal course of events at the end. Normally you ask me questions. I'm going to ask you a question. Or maybe to do more than just answer a question, to comment. And the question is going to be, what do you think should happen if we ban hydrofracking? I think somebody chuckled, but again, I don't find this funny anymore. This is real. What do you think happens if we ban hydrofracking? Because that's where we're going. That's what the call is for in New York right now. Talk about the law of oil and gas in New York is a pretty daunting task right now because there are presently 120 Pause and think about that for a second. 120 what? 120 pieces of individual legislation pending in New York State related to oil and gas drilling. We cannot even drill the Marcellus Shale right now. There's 120 pieces of new legislation pending, several of which, incidentally, are outright bans. So at the end, I think I want to ask you that question again. What are the implications for us if we actually do what not just some, not just a few, not what I used to just refer to as the radical anti-drilling fringe, what I would now call a growing number of mainstream Americans want to do, and ban the process? I'm going to use these old slides that I have because I think that they'll help me frame some of the issues to talk about. First one I want to talk about 5 or 10 minutes, talk about the legal aspects of it, is can you really have a vibrant natural gas industry or any natural gas industry in New York? We're going to talk a little bit about the oil and gas lease as it relates to property rights so that you understand what that aspect of the industry and what they need to do to actually start the process of developing natural gas. I'm going to talk a little bit about a new phenomenon, about 2 years old, the landowner coalition. It's something that most of you probably wouldn't know much about at this point, but when we get there, I'll explain it in some detail. It is exactly what it sounds like. It's the aggregate of landowners and community owners now getting together to lease their oil and gas rights in bulk. I'm going to touch upon that all-important concept of compulsory integration, which, if any of you read any media reports on in the last, say, 6 months, and I asked you a show of hands how many people think it's an unconstitutional taking, I bet I get probably 90%. We're going to talk about the process of unconventional shale gas spacing, laws associated with pipelines and infrastructures. We will not touch on the who, what, when, where, why, and how, because you probably don't care. But I'm going to finish with some very broad discussion about positive versus negative rights and where I think that we're going, both in the country and in the state as it relates to, I was more clever than I thought. The time I gave this talk, I hadn't done it nearly so many times. I wasn't sure I'd actually get through it, so I think I put the conclusions first. This tells you how naive I was. Can industry do business in New York? I emphatically said yes. Obviously, that slide is outdated. The answer is no. This was just after the governor demanded DEC do the SGEIS. People thought it was going to be a 6 to 8 month, maybe a 12-month process. We would be drilling by the end of the summer season in 2009. Well, obviously that didn't happen. In terms of conclusions about an oil and gas lease, if you take nothing away from anything else I say, know this. Oil and gas lease is a freely negotiated agreement between you, the landowner, and the oil and gas operator. There is no power of eminent domain to oil and gas companies in this state or in any other state. Why is that significant? Well, today it's significant because it goes to the issue of what does the average person, call them the consumer in this particular relationship between, meaning the landowner and industry, want. With millions of acres in New York already under lease, freely negotiated, nobody can force them to do it, I would say it's a pretty good indication that the public, at least in the southern tier, wants natural gas development. If they didn't, don't sign. Don't take the money. Tell them to go away. Because they can't come on your land if you don't. In the absence of those freely negotiated leases, ladies and gentlemen, there is no domestic natural gas industry. The process of compulsory integration. This talk wasn't very good, apparently. If you take nothing away after the leasing issue, of course, about compulsory integration, it's not coercive. It's not a taking. What it's actually for is to prevent the over-drilling of a resource and to make sure, in fact, that your property rights aren't taken. There's a different spin, right? Can you be forced into a spacing unit? Can you be forced into a unit of drainage from a gas well? Yes, you can. I'll explain how that happens. There's no question that you can be forced in, but you're forced in with options. You're forced in with the option to develop your rights. You're forced in with the option to develop your rights and have somebody else pay for it. You're forced in with the option to receive a royalty. And you always have the ability to negotiate an agreement, whether it's a lease, whether it's an operating agreement. You have a lot of options available to you. What the process is actually for is to prevent too many wells from being drilled too closely together. I worked on drafting the well spacing and compulsory integration laws that were enacted in 2005. And when we did that, and by the way, it was a large group of interested stakeholders representing large segments of industry, small segments, mom and pop producers, individual landowners, the Attorney General, the Department of Environmental Conservation, the Farm Bureau. There was a lot of people at the table. And when we were done, everybody who was involved in that process thought they had done something really remarkable. I thought they had revolutionized the way New York was going to approach oil and gas drilling and the treatment of property rights going forward. To me personally, it's pretty disheartening to see what it's been characterized as now. Let's skip over this. You've already heard about the long history. You've heard about the wells. You probably don't really care about how much production there's been in recent years. What you really want to know about is what the legal paradigms are. For those of you who are interested in doing it, which is going to be nobody, Article 23, Section 0301 of the Environmental Conservation Law is the declaration of policy as it relates to oil, gas, and solution mining in New York. And it says that it's declared to be the policy of the state of New York to promote the greater ultimate recovery of oil and gas, to prevent waste, and to protect the correlative rights of the landowners, interested community members, and the industry. That's the declaration of policy for the DEC as it relates to oil, gas, and minerals. And think about it. It's actually the policy of the state to promote oil and gas development and to prevent waste. And incidentally, I'll give you a little bit of historical background. In this context, waste doesn't refer to what we would today think of it as. It's not really talking about environmental waste or degradation. What it's actually talking about is waste of the resource. That's how far we've come. When the law was enacted, waste actually meant don't put in too many wells, because if you do, you reduce your reservoir pressure and you reduce the amount of oil or gas we can actually extract. That's the historical vestige of it. Against that background, the next thing you need to understand or know is what are your rights as a property owner? I ask this question all the time. I formerly taught at the law school here. I'd ask the students. That's the question almost every lecture I've given. What do you think that you own when I talk about oil and gas rights? And almost universally, people believe they own the oil or the gas underlying their property. Categorically incorrect. You have no right to the oil or the gas underneath your property. None whatsoever. What you do have is the exclusive right to explore, drill for, and produce the oil and gas underneath your property. And I want to make sure that everybody understands the significance here. Or let me just ask the question, we'll get the general nod of the audience. Does everybody understand the distinction? No. No. Of course not. That's the general answer. Oil and gas in the subsurface flow back and forth. It doesn't stay in nice, neat little pockets that honor geopolitical boundaries at the surface of the Earth. If you remember back to Dr. Smith's talk last week, you have these large anticlinal structures where historically would look for oil or gas, where the source rock would be underneath. It would migrate up into a reservoir. There'd be a seal over the top of that, and those would be the points that you'd drill. Well, that's all related to geology, not related to politics. When you have a source rock like the shales that you're now developing, they are broadly dispersed. Poor geological term, but basically everybody knows what I'm talking about. Almost like sheets, if you were to look at it from a map view down. And when you drill into those formations, the gas, if it's hydrofracked or if it's in something like a sandstone reservoir, moves. They used to refer to it with a Latin term, feri naturae, meaning it runs with the wild. It's how the early courts analyzed oil and gas. It moves in the subsurface and it flows. So if you put a well on parcel A and turn it on, and it starts to produce, do you know that it just came from that particular tract of land? Let's say you have a 1-acre housing lot. Put a gas well in. Are you only draining the gas from that one little block? Sound logical? Of course not. In reality, you have no idea where the gas is coming from. At least in the early days. They're now better about it. But either way, it doesn't match up to the surface. So to prevent the issue of somebody taking your property without your consent and realizing that there's no way to actually know, what the early courts did is they created what we call a legal fiction. We're just going to deem this to be the case. And what we deem is that your property rights aren't to the oil or the gas. They're the right to go get it. It's a pretty simple concept. And it doesn't matter whether you have 1 acre or you have 100 acres. You put the well in, you go down, you produce the gas, you're entitled to all of the gas that you produce, or all of the oil you produce. And it leads to draconian consequences. Let's see if I can end this slide and show you a picture. Bear with me for just a second. No, we don't want this. Beaumont, Texas, circa 1903, the Spindletop oil field. And those are oil derricks, and they are sitting literally as close together as you could possibly put them. That's what happens under the strict interpretation of property rights as they now exist. Who thinks that this is a good idea? Look at the consequences of that. Think about the surface impacts of it. Think about what this does to the environment. This is what happens if you don't have reasonable government regulation. This is what we aimed to prevent when natural gas development became a big issue in New York State, is this. This is what happens when you just freely develop your mineral rights. Everybody with 1 acre who's about to be drained by their neighbor has to do something. And the only thing that you can do is drill your own well. And that's what this is. This is everybody and their brother drilling as many wells as they possibly can. This is what property rights actually do. This is the so-called offset drilling rule. And it's about as damaging to the environment as you can reasonably get. So what we did, actually starting about 1953, is we came up with the concept of well spacing and compulsory integration. And said, we're not going to take your property rights away, because we can't. It would be an unconstitutional taking. Why don't you guys figure out how to, Marcus, can you figure out how to get the PowerPoint back up? That's why I asked you to get it back up. Thought I was clear. So what we had to do is find a way to recognize the fact that you have the right to drill, explore, and produce oil and gas from your property, and somehow harmonize that with this concept that that's all you have, and you don't physically own the product that you produce. So we create this legal fiction that says you have the right to drill it, and when you produce it at the surface, it becomes personal property, and it's yours, all that you can produce. To prevent the waste, you come up with the concept of creating a spacing unit. Oh, good Lord. I'll find it.
Yeah. I can't tell which one it is. I picked the first one.
That's all right.
Yeah.
So the first thing that you do is you create a standardized area of drainage. And we do this in New York on a formation-specific basis. If you look in section 230503, 1A through G, you will see formation-specific spacing units for all of the known natural gas producing formations in New York. We have specific spacing units for shallow oil wells. We have Medina units at 40 acres. We've got, on the other end of the common spectrum, we've got Trenton Black River spacing units at 640 acres, and a variety of units in between. All based on the fact that pretty much every state but New York is mapped out in sections, 1 mile by 1 mile lines, which is where the fiction comes from. And what we say is that once you get a permit to drill a well in a particular formation, the state, under its regulatory powers, is going to create a unit, a square, basically, with 1 well in it. And whoever's property is located within that unit, those boundaries, and the boundary is set over the top of basically a tax map, you're included in that spacing unit. And we're not going to allow those wells to be drilled any closer than that. So there's distances from wellhead to wellhead, largest up to 1 mile away. The shales, incidentally, will be 1 mile away. And all the property owners inside those units are going to share ratably in the production from that unit. And frankly, it doesn't really matter whether you're under lease or you develop your rights independently. You're still going to receive some compensation, whether it's the royalty under your lease, whether it's a working interest through the compulsory integration process, based on the amount of your acreage in that unit. What that does is it basically equalizes everybody. It treats you all the same. You're all getting a pro rata share of production. And you're protecting correlative rights by giving people in the unit their pro rata share of production and allowing people adjacent to you to drill and develop their own wells, presumably through a company. You don't leave any of the resource necessarily untapped, and you don't over-drill it. In New York, we actually came up with a system that was so incredibly easy. It's actually a check-the-box regulatory scheme. If you find yourself in one of these spacing units and you're not leased, you're going to get a form in the mail. It's quite literally a one-page document. It's not very complicated. And there's a box on each side, and it'll give you 3 options. It'll give you the option to participate as what the state calls an integrated participating owner, which is exactly what it sounds like. You essentially become an oil and gas operator of your own property. You put up your proportionate share of the cost of the well, whatever it happens to be. You take your proportionate share of the risk, and you share in all the benefits of the well, whatever they may be. Of course, you also share in the liabilities of the well, and I only know 1 or 2 people in the history of the Compulsory Integration Act that have ever done that individually. But if that's not fair, you also have the option of being what we call an integrated non-participating owner, which is also just what it sounds like. You join in the unit, and you pay your proportionate share of costs, except that you don't actually pay them out of pocket. You pay them out of production from the well. So somebody else pays for your costs to drill the well, and then if the well produces, they recoup their money, and to be fair to them, we allow them to have a risk penalty, which in New York happens to be 200% of cost. So if your cost was $100,000, as the well begins to produce, the operator or the person who put up your proportionate share of the costs gets to recover $300,000, and after that, you get to receive all the gas attributable to your property or the cash equivalent of the gas. Again, unfortunately, you carry with you all the risks and liabilities that goes into drilling and developing natural gas wells, but it's actually it's a pretty good option. It's probably your best option if you're not interested in leasing your rights to an oil and gas company. Just wait, see if the well is developed, and take your shot. If you want absolutely nothing to do with the oil and gas industry, and your property happens to be included in one of these drainage areas, you don't have to do anything. But you'll still receive revenue if the well is productive. You'll get a royalty equal to 12.5% of the production, which at the time the statute was written was pretty much the standard royalty for every oil and gas lease in the state of New York, barring some extraordinary exceptions. That level has actually come up. I would say on average it's probably now somewhere in the range of 15%. And the statute actually took that into consideration, and what you actually get is the lowest royalty in the unit, but not less than 1/8. So if everybody else is at 15%, you're at 15% too. And you still have the option to sign a lease. So the issue becomes, how are these spacing units formed? How does this process actually work? Well, in 2005, when we were putting together those little blocks, depending on the producing formations, nobody had actually produced any shale wells. The so-called shale revolution hadn't started yet. So the statute was silent on the issue. Didn't know. 2007 comes along. People start to get excited about the Marcellus, start to think about the Utica, and a land rush was on. Hundreds of thousands of acres leased, particularly for shale gas development. And the New York State Department of Environmental Conservation did not have the ability to apply this fairly uniform, predictable process to the creation of units for the shales. And they were confronted with the very likely prospect that they were going to receive large numbers of drilling permits for wells for which they didn't have a set uniform size, and they didn't know how to handle that. We have what's called an unconforming unit policy that enables you to create an area of drainage outside the strict confines of the statute, but it's a fairly arduous process. It's more difficult. It requires a factual hearing in each and every case. And so the DEC said, we can't do that. It's going to affect the efficiency of our regulatory program. And they quite literally drafted their own legislation and took it to the legislature. And this is what it it consists of. If you have a conventional vertical shale well, your spacing unit is going to be 40 acres with a wellbore no more than 640 feet from a unit boundary, creating a box within a box. These couple of graphs are basically the only reason I put up this entire presentation. This is basically be the same size as a Medina well that we have drilled countless times in New York. And what happens is you put a well, to create some flexibility, instead of putting the well directly in the middle, there's a 220 foot by 220 foot setback area, and you can put the well anywhere inside of there. It takes into account things like topography, wetlands, creeks, drainages, and this is the unit size for every vertical shale well that would be drilled in New York, which would be very few, if any. So then the DEC had to deal with the issue of large horizontal wells. They hadn't seen this before. But nobody actually knew what the size of them was going to be. And to this day, we still don't know. The average horizontal well in Pennsylvania in the Marcellus is probably 4,000 to 5,000 feet, but I've heard companies have now drilled out as far as 7,000, even 8,000 feet. Doesn't seem like that's going to be viable, but that's just part of the process of technological advance. New York State took that into consideration before they permitted any wells. And what they allow for in New York is what we call a growth unit. You have setbacks of 330 feet from the wellbore to the sides, meaning that well can't be any closer than 330 feet from an unleased property boundary. Oops. Here, 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 and at the end. But what we're going to do, or what the state's going to do, is they're going to allow the operator, the drilling company, who has the technological knowledge, has the experience, has the information, has that innovative technology, to decide how big it's going to be. We're not going to force them into a box. All we're going to say is, at the end, you have to leave at least 330 feet. Those setbacks are so that we're protecting the adjacent properties from drainage. That's what they're for. They're for no other purpose. And as long as the company can drill, literally meaning as long as they can drill, the unit just continues to grow. Out to the very end, wellbore stops, add 330 feet to the end of it, that's your unit. That's how it works. Then that whole process of sending out the form to the landowners in the unit with your options begins. Here's where it gets interesting. Again, I want to emphasize, this is in 2008. This is before we have any knowledge or experience about what was done in Pennsylvania. This is just based on what operators were predicting would happen in New York. This is 640 acres. The largest unit size you can have in New York is 640 acres, although without even drilling any wells, we're already talking about doubling that size by putting well pads next to each other. What you do here is put a single well in the center, represented by the box, and then operators can drill out laterally. So the well bore literally goes in this direction, turns, and the horizontal section is in the target formation. This particular, they now look like pitchforks, incidentally. Mostly what you see is a well going out this way, going out this way, going out this way, going out this way. At the time, we really didn't know. I actually took this from one of the largest operators in New York. They sat down and explained to me what their pattern looked like, and they had 16 wellbores projected for a single unit. What's elegant about it is that they drill them all from a common pad. They've got these great things called walking rigs. They show up and they've got 4 giant legs on them. They put the rig up on the pad, they go down, they drill one section, strip the pipe back out, and they literally move the rig. It just turns over, moves 20 feet, they start drilling another one. The whole concept behind this common pad multi-well design, in New York anyway, was initiated by the Department of Environmental Conservation. Certain operators thought that they would be drilling wells this way. Many did not. This was not standard operating procedure at the time. But in New York, with some foresight into the process, the DEC said, no, we need a way to, if we can, lessen the surface impact while still doing those other things that we have to do. Protecting relative rights, promoting the greater ultimate recovery of oil and gas. And this is the concept they came out with. In fact, the regulators were ahead of the industry in terms of what they wanted to do at the time. There's more to this. Unlike Pennsylvania, Oklahoma, Texas, if an operator proposes to do this, you actually have to finish it. Imagine that. When you get your permit to do this, the permit only lasts for 3 years. So you can permit 4 wells, you can permit 6 wells, you can permit 16. You only have 3 years to drill them. People were concerned that a company would come in, they would create one of these large units, they would put in 1 well, they would hold a square mile of acreage and go drill the next door neighbor's property, so they end up with a patchwork of wells. I don't know anybody who would actually invest the money in doing that, given how inefficient it would be, but that was the concern. So in New York, you can't actually do that. You have to, once you start drilling, complete the process and develop the wells. Now again, what I find really interesting about that is this was in 2008, and what the state and the property owners and the Farm Bureau and the Attorney General and all the other interested parties were worried about was actually making sure somebody drilled wells. You can't help but compare that to the irony of today. Does anybody know what happened after this legislation was enacted? Nothing. Because as this legislation was being contemplated by the legislature, there was a groundswell of concern out of residents in New York City about the potential impacts of a process called hydraulic fracturing, which until 2008, I would bet in this entire room, 4 people have probably heard of, or would have heard of. And I picked 4 because I'm looking at the professors from the Geology department who know what this is. This wasn't common language, and trust me, if you were to have a lecture series on the Marcellus Shale, you wouldn't get 10 people to show up to 1, let alone 150 people to show up to 8. But there was this groundswell of concern about what would happen. And after, I should say, the law was passed and it was sitting on Governor Patterson's desk, quite literally, 11 o'clock in the evening, he placated the concerns of the New York City constituents by saying, no problem. We'll just have the DEC go through this process of updating the generic environmental impact statement before they can go ahead and do this. The presumption was that this was a 6-month-long process where they would study the delta or the difference between the impact of fracking with 80,000 gallons and the process of fracking with up to 3, 4, 5 million gallons of fluid. And that is how the whole thing got started. It actually got started simply because we wanted to create an orderly system of well spacing. And the outcome has left us now 3 years down the road without the ability, ironically, to drill the wells that the statute was meant to encourage. Just checking the time. Once that process was over, meaning the process of spacing the well, drilling the well, achieving production, the difficult part actually begins, at least in the eastern US. And the difficult part is selling it. Doesn't seem like it would be a terribly hard thing to do. Obviously, there's a market for it, but you need to actually get it to market. And if I had the talk that I wanted to have, there'd be a neat little map up here of an aerial photo of about 5 square miles in Chemung County, New York. And it was just picked at random off of a Terra server, I think. And what you would see are creeks, wetlands, roads, schools, etc. And what that creates is a logistical nightmare. And I bring this point up because one of the things that I hear all the time in doing these talks is that the New York countryside is going to be turned into some desolate industrial landscape because there's going to be well pads located in every conceivable place possible. Well, that's not going to happen. It's not going to happen because I say it isn't going to happen. Frankly, no one cares what I say. It's not going to happen because we have laws to protect things like that. We have historical sites. We have wetland regulations. We have stream crossing regulations. And all of those logistical things need to be taken into consideration just to move the gas from the wellhead to a point where it can be sold. It's probably the most difficult logistical aspect of drilling a well. Let's see if I can go back. No, we'll leave it up. One of the things that has been happening over the last couple of years is that landowners and landowner coalitions have got into this market. They've seen an economic opportunity emerge. And what's the opportunity? It's the pipeline. There's money in that there pipe. They're not actually interested in the gas. Hopefully they're going to get that on the drilling side. What they're interested in is a per-foot fee for the pipeline. It's now standard operating practice to go out and obtain rights-of-way for these gathering systems to move the gas. So obviously you're restricted by the different impediments that I mentioned, so you now have a limited number of pathways that you can. And what I've seen cropping up in leases beginning around 2005, 2006, and now happening in almost every lease today is the exclusion of pipeline rights in an oil and gas lease. You can drill the well. We'll give you the right to explore, drill, produce, market, but not move. Sorry, we're going to handle that one separately. And the prices for that have now gone from about $5 a rod, about 6 feet or so, to $50 a foot on average. It's a tremendous economic opportunity. And of course, what's the surface impact of a pipeline? Nothing. You need a right-of-way, maybe 30 feet wide, a little ditch witch, pipe goes in the ground, your fill goes back in. They use a double ditch method. Topsoil goes on one side, fill goes on the other side, goes back in. If it's done before the growing season, it can actually be used in that season. If it's done later in the year, it's returned to normal by the next year. Just to throw some law in here, this is one of the areas where the petroleum industry does have an exemption. I'll be the first one to tell you that there is an exemption. There's an exemption from Common Carriage, which means, not what you think, it means every pipeline is owned by the company, and no one else can use it. Even if there's capacity, even if there's space, no one but the company that built it has the right to access that pipeline. They're still subject to all the safety regulations of the Public Service Commission, but they don't have the Common Carriage regulations. What that means is gathering systems in New York, midstream systems, are privately owned. What typically happens to them is after an area is developed, wells are developed, the field begins to age. A lot of people have concerns about the infrastructure going to waste. Historically, that's not what happens. They get turned over and bought out by the local distribution companies and now are used as distribution lines. Instead of taking gas from the well to the line, you reverse the direction. You take the gas from the line outward and you provide community supply lines. But it's interesting that 66 G3 exemption that exists creates a lot of competition among companies for rights-of-way. As they're looking to develop their acreage, if you had a map on the wall, you might see a block of yellow representing all their leases. 10 miles away, on a thin blue line or something, you'll see a pipeline. And the acreage along that pipeline route is some of the most valuable acreage that they have. And believe it or not, companies do use that to force their competition in the marketplace into deals with them because you can't move gas without a pipeline. Forget infrastructure. If I had the talk I had, which I don't, the very last section of it is the section that is probably now the most near and dear to my heart. It's a section on positive versus negative rights. And just a quick show of hands, does anybody know what that refers to? Excellent, we got a couple. Well, and my associate who's sitting there chuckling, he knows what they are. This is something that I have become very concerned about. We are going, both in New York State and at a national level, we're making a shift from a legal system based on negative rights to a legal system based on positive rights. And I don't think anybody truly understands the impact of doing this. But to give you, you need some background. The best example of negative rights is the Bill of Rights to the Constitution. And it basically describes what the government cannot do to you. You have freedom of speech. Sounds positive, but it's actually in the negative. The government does not have the right to suppress your speech. You have the right against unlawful search and seizure. You have the right against imprisonment without due process of law. These are negatives. And the way the system is set up is that individuals have all of the rights unless the government specifically enacts a law that is, generally speaking, meant to protect human health or the welfare that takes it away or modifies it. Think about the penal system. What it does is it tells you what you cannot do to others. And it exists for good reason. But if it's not specifically codified, it's not illegal. You own that full panoply of rights. And that's the system that we have. What we're now going to more frequently is a system of positive rights. And the best example of a positive right that I can think of is Social Security or Medicaid. It's the government saying, you have the right to X. And if the government grants you the right, the problem with it is the government then becomes responsible for seeing that it's carried out. We call these euphemistically entitlement programs. And we're now going in a direction where we're talking about the right to food, right to clothing, right to shelter, right to health care as positive rights, and someone's going to supply them. Do I have anything against people having food? Of course not. Do I have something against people telling me that I'm going to have to pay for it? No, I do. But this is about oil and gas. So how does this become relevant? Well, it becomes relevant because in this debate, what we're seeing are people talking about risk. And you've heard the question, if you've been to the last couple of lectures. Can you tell me that this is not going to happen? Can you tell me that there won't be any spills? No. Can you tell me there won't be any contamination? I'm a scientist. No. I can tell you there hasn't been any. But can I tell you there won't be? Of course not. And what this has led to is a call for either regulation or a moratorium on an action until you can provide that level of certainty. And of course, it's unobtainable. There's not a scientist that I know that is going to use that word never with any degree of confidence. I can't say never. I say it's highly unlikely. I can say, you explain the science that goes into the process, but I can't answer that question. So what we're moving in the direction of is until you can take away all that risk, we want the government to say no. We're going to create a positive right. We're going to give you the right to be free of risk. How in God's name do you enforce that? And it comes to the question that I was asking at the very beginning. Let's circle back around and let's look at 51% of the homes use natural gas. 23% of the power in the country is generated from natural gas. 90% of the wells that are drilled are hydraulically fractured. Is there some element of risk? Absolutely. If I have to remove all elements of risk, can I do it? No. What are the implications of it? Thank you.
Thanks, Mike. You got through it despite the lack of slides. Let's take a 2-minute break as per usual. And if people need to go off and watch the game, or you just want to stretch or something, and do so. And then we'll start again in 2 minutes with any questions from students and then the general public.